Yeah.
Yes.
So thank you very much for coming here and online. I'm Thomas, as you already have heard, one of the directors, and this is the Sussex AI seminar series. And today we have Beatriz talking to us when deepfakes go viral. I'm really looking forward to find out more about that. And I think without any further ado, take us away.
Thank you so much. Thank you. I'd like to start by thanking Sussex AI and the team for inviting me to present this research. This is something that I started this year, so it's quite new, and I very much welcome feedback and comments. I know people in the room, both online and physical room, have different kind of areas of expertise than myself. So people who have expertise in criminology, in more technical aspects of AI. So that'll be really good to hear from you as well in terms of areas where the research can expand further and things that I haven't considered in my analysis. But maybe a little bit of myself and where I come from in terms of this research. I'm a lawyer by training, so law. I'm a lecturer in law as well at the Department of Law here at Sussex. And I had also some training in social sciences of the internet. So I have been hanging around kind of social science, kind of social sciences and computer science that looks like that apply computational methods to study social science topics for a while. Even though it's not my primary area of expertise, I do try to have a little bit of interdisciplinarity, or at least look at research that has been going on outside of law when doing the work. And this is kind of my first attempt at looking at the issue of deepfakes. And then I come from the deepfakes kind of area from the regulation of social media angle, which is my primary area of expertise. So as a lawyer, I focus on studying regulation of digital platforms overall, but with a strong focus on regulating social media, regulating content, and that spans through aspects such as dis and misinformation, kind of abuse, all sorts of online harms, broadly speaking, and then again, deepfakings emerging as one of the new forms of harmful content online, and how should law or could law apply and regulate those issues. So this is kind of the background of the presentation. So the issue of deepfakings emerging online and being shared and disseminated and consumed and produced through platforms. So the issue of deepfakes being not only created using technologies that are easily available online, like apps or websites, but also being shared and being disseminated and being amplified through digital platforms. And here are some examples of recent pieces in the media that have kind of exposed the issue or brought to kind of the wider public attention, something that has actually been going on in different formats, in different shapes for quite a long time. So we can say that the exposure of people's intimacy on the internet through deepfakes, but not only through deepfakes, could be said as a form of image-based abuse or image-based sexual abuse, which is a form of abuse that predates AI. So deepfakes being, and we're going to go into the details in terms of the definitions and why we're talking about what we're talking about when we talk about deepfakes, but the idea being that image-based sexual abuse being around for quite some time, even before deepfakes were so easily available as a tool for people, for ordinary people, when that idea being the intimacy of individuals, the bodies, and the intimacy, especially of women, being shared without their consent. And of course, we can look at the data, and that is data from between 2015 and 2021. So again, that's before generative AI has been so readily and easily available to the public. 1 out of 7 women between 18 and 24 in the UK had reported experienced some threats of shared intimate photos online, and 28,000 people in the UK during that period disclosed or reported some form of image-based sexual abuse. And we should also mention that this is a form of crime or a form of abuse that often goes underreported. So the actual number can be much bigger than that. And as many forms of image-based abuse, deepfakes or intimate deepfakes disproportionately target women and girls. So if you look at the sample of near 4,600 videos that one industry report looked at online, out of the sample, 98% of the videos that were regarding deepfake were deepfakes that were intimate in nature, so showing intimate images of humans, and in 99% of the cases, the victims were women. Again, that's a small sample that was examined in that report in 2019, but that also reveals, like I think the percentage is quite high that really shows a trend in terms of who is most targeted by this form of abuse. And then coming from this topic, from kind of a law perspective, or from the perspective of a lawyer looking at the issue, the question that I was asking myself is like, what is the current law? What are the protections that we currently have in place in the UK to respond to that trend? So if you look at the evolution of the technology and how much easier it has been to produce deepfakes, and that deepfakes or generative AI technology that produces deepfakes have been often used to create harmful, abusive image, especially of women. What does the law say about it? And how can we prevent the creation and dissemination of this form of abuse using the legal tools we have at our disposal in the UK? So one of the things that I started looking at when looking at the issue was the recently approved UK Online Safety Act. And that was a legislation that UK approved or received royal assent, so the final stage of the legislative procedure in October last year, 2023. And that was hailed by the government at the time as making the UK the safest place online, the safest place in the world to be online. So kind of a bold statement. And amongst the different areas that the law was aiming to be protective and to create the safe environment, and that was supported by Ofcom, which is the assigned regulator responsible for enforcing the law, is to protect women and girls online. So if the UK has this kind of landmark piece of legislation that has been so recently approved, how well does the Online Safety Act regime does in fact protect women and girls and people in general against the harms of intimate deepfakes? And does it protect against the production, the circulation? What is the really the safeguards that the legislation offers? And one of the other things that I was looking at, if perhaps one of the hypotheses is if the Online Safety Act, or the OSA for short, in terms of acronym, is not sufficient, what other regulations or other areas of law could complement the Online Safety Act regime and provide a level of protection in that regard? So these are kind of the guiding questions of my research against this background. And then to address these questions, I looked at 4 different areas, so kind of 4 steps in terms of addressing the problem. The first was to look at the concept of intimate deepfakes or non-consensual intimate deepfakes. And this is a form of deepfakes often referred to as deepfakes porn or deepfakes pornography, but I'm going to discuss why I don't think that is a good term in a second. Then the second step is once I've defined the problem, the issue that the law should be looking at, how well does the Online Safety Act regime apply to it? What does the law create? What does it put in place? What are the different kinds of duties and obligations and rules that came into force recently, and how can they actually support victims of this form of abuse? Then looking at the role of social media platforms, which is kind of my area of research, but also because given the role they play in amplifying, disseminating the harmful content, and the fact that the Online Safety Act does place obligations on social media platforms, how well are they actually protecting people, or how are they actually enforcing their private rules with regards to this form of harm? And then the final step, in terms of the final bucket of issues that I looked at is upcoming AI regulation. So part of the question, the second question that I was asking myself is, if the Online Safety Act is not sufficient, can we think about other forms of regulation? And one of the forms of regulation that I think could be a good complement to the current framework is AI regulation, and I'm going to talk about that as well. So this is kind of the map of the presentation, the 4 issues that I'm going to be discussing with you today. If at any point you have any questions, any comments, want to kind of raise your hand or just unmute yourselves and say anything, please feel free to. I'm very happy for this to be more of a conversation than kind of a me talking at you style of lecture. Okay? Okay, so what do we talk about when we talk about the concept of non-consensual intimate deepfakes? And I know it's kind of a mouthful here, and I did try to create a kind of acronym NCID to make it a little bit more catchy. But the idea is that deepfakes being the kind of combination of deep learning and fake, being a form of media that synthesizes the person's likeness in a video or an image or an audio through using AI technologies. So synthetic forms of media creating using AI technologies that represents the likeness of a person. The issue in terms of the UK law, there is no definition of deepfakes in the legislation. The law does not at the moment, and there are some amendments and some proposals being considered. In the UK, there is no kind of legal definition of deepfakes yet. But we can look at a legal definition from another jurisdiction, so that's the EU AI Act definition of deepfakes as being AI-generated or manipulated image, audio, video, content that resembles existing persons, objects, places, or the entities or events that would falsely appear to be a person, to a person to be authentic or truthful. And look at the definition here in the EU AI Act. It's not only about the resemblance of a person, but it's also, which for me was a bit surprising, including the definition of deepfakes, syntactic objects, places, or entities. So that's something that we could also question if that's perhaps the most adequate definition of deepfakes that we could think of in terms of the UK landscape. But that being said, the UK, again, doesn't have a definition, but we are familiar, and in terms of the technical kind of context, deepfakes is understood to be some form of synthetic media that resembles a person at the very minimum. But then a lot of the media attention and discussions and the public debate has been labeling the issue of people's intimacy being exposed to deepfakes as a form of deepfake porn or deepfake pornography. And I see that as a problem because in the UK, as in many other places in the world, pornography is not illegal. Pornography is legal. In fact, the UK government has been recently conducting a really big review of the pornography regulation in the country and associating the idea of deepfakes that exposes someone's intimacy, a form of deepfake that's a level of abuse that it embeds, to something that is legal, like pornography, conflates issues that should not be conflated, conflates 2 forms of content that should not be conflated. So one of the kind of normative arguments that I make in my research is that we should not be labeling or we should not be referring to that form of image-based sexual abuse as porn, deepfake porn or deepfake pornography. So that's why I propose this kind of mouthful label of non-consensual intimate deepfakes, because I think it captures much better the nature of the harm. It is abuse, it's a form of sexual abuse. It is non-consensual, and it's intimate in form because it exposes people's intimacy. And that, again, shifts the focus of the discussion to the victim, to the person being portrayed, to the person being exposed, rather than the person consuming the images or viewing or kind of benefiting from the harm, which, again, if you associate the label pornography, would be something that would be easier to think about. And then the kind of umbrella term that I'm associating with non-consensual intimate deepfakes, or NCID, is the form of image-based sexual abuse that have been proposed by professors Claire McGlynn and Erica Rackley in this kind of very seminal piece of work from 2017, where they define broadly image-based sexual abuse as non-consensual creation and or distribution of private sexual images, and that could fit very well this kind of intimate deepfakes, because there's a range of ways this kind of intimate image, private sexual images can be created and or distributed without the consent. So again, the concept is broad enough to accommodate the forms of deepfakes that we are talking about, and is much more precise than labeling it as pornography, for the reasons I already mentioned. And then the third kind of point in terms of the looking for a concept for trying to define the problem of non-consensual intimate deepfakes is that the question of how different it is from the other forms of image-based sexual abuse that came before. Are we really talking about something new here? Do the kind of remedies and measures and safeguards that we have in place for non-syntactic forms of image-based sexual abuse is still effective? Do we need to talk about, are we talking about something different here? And one of the arguments that I make, and again, you're welcome to dispute that or share your views, is that in terms of the harms it infringes on victims, in terms of the nature of the harms it creates, and as a series of kind of individual and kind of society-wide harms, not only in terms of privacy, but sense of security and intimacy and having a place in society. There's so many different harms. The fact that the content is real or not makes very little difference. Whether someone's intimacy is being exposed through a real photo or through something that has been computationally created doesn't really matter for the victim, from the perspective of the victim. What does actually creates a new dimension to the problem that might require some different level of responses is the ease of creation and the ease of sharing and disseminating this content. And I say that for two main reasons. One is because, differently from other forms of image-based abuse, in many cases, we don't need some kind of, for the creation of this form of deepfakes, there is no requirement for any kind of real intimate images to exist in the first place. And we've seen from some of the technologies that have been around that having just photos of someone's face is enough to create this form of content. So anyone is a victim in potential. And I don't want to go into the kind of victim blaming route that, oh, if the person created some intimate content to begin with, then it's their fault. I think this is absolutely wrong. But the fact is that anyone, have they created or not any form of intimate content, could be a victim of this form of abuse. So that expands the universe of people who could potentially be targets of this form of harm to a much larger audience than we are currently talking about, or we were previously talking about before the emergence of AI technologies. And that's the second thing I think that is important in this kind of new dimension that deepfakes bring is not only that anyone can be a victim, but pretty much anyone can be prosecutor, can be the person creating the kind of harmful content. Because the technology made it so easy, the barriers to entry are so low, the apps are available to download and install on your phones, that anyone could potentially create these forms of criminal content. So again, the problem with deepfakes or non-consensual intimate deepfakes, from my perspective, is not that the harms it inflicts are different. It's just that the likelihood of the content being created and shared, it's because it's so much easier and cheaper and anyone can be a victim, there will be a flood of new harmful content that will require good and kind of effective safeguards and protections. So this is kind of the setting of the problem. So that's what we're talking about. And then the question is, how well, and sorry, that was the slides talking about the mismatch between the dimension of the problem and the solutions. And just to add, one of the issues and one of the focusing on non-consensual intimate deepfakes as a standalone category of deepfakes is that it also reveals how many of the solutions, the policy solutions, or the kind of private solutions that are currently being discussed for other forms of deepfakes, and I'm thinking about misinformation here, or some kind of like electoral harms that could be associated with other forms of deepfakes, are really inadequate when you think about intimate deepfakes. If we don't specify what types of deepfakes we're talking about, we run the risk that assuming that this labeling and watermarking kind of solutions are kind of a silver bullet that's going to solve the deepfakes issue, when you talk about intimate deepfakes, that is clearly not the right solution. So labeling and creating a good kind of concept of we're looking at also helps to shape more effective legal responses. And there's some emerging research that reviews that the focus on a lot of the policy and public debates on deepfakes is kind of very, very much skewed towards misinformation and the harms to institutions and democracy, and not really reflecting the real actual harm that these technologies are already causing to people, especially women. So when we talk about deepfakes focusing only on misinformation, and platforms and different kind of economic players, corporate players make pledges to tackle deepfakes, but only looking at one dimension, we leave a whole world of harmful content not properly addressed. So this is why I'm arguing we need to talk about non-consensual intimate deepfakes as a standalone category of deepfakes, not because the harms it causes are different, but because it requires legal and policy solutions. So what does the UK have in place at the moment? So the flagship legislation, as I mentioned, is the UK Online Safety Act, which came into force last year in 2023. And the Online Safety Act does many things at one time. Like the legislation itself is over 234 pages long if you create a PDF. There's a lot to unpack in the law, and I've been trying to do so for the past almost year now. But one of the, like in terms of the three buckets of issues that relate to the topic of intimate deepfakes that I want to talk about, the first being new offences that the law introduces. So with the law, Section 190 of the law amends the Sexual Offences Act and changes the description of both the actus reus and the mens rea, so the guilty act and the guilty mind, the crimes that it describes, the offences it describes for image-based sexual abuse, to be, in theory, more fit to deal with the problem of deepfakes. So these are the new provisions that the Online Safety Act introduces to the Sexual Offences Act, creating new forms of image-based abuse, which in a way make the concept wider. Any form of intentionally sharing a photograph or film which shows or appears to show another person in an intimate state is an offence, is a criminal offence. And also the law amends the definition of photography or film in a way that also it includes images made and altered by computer graphics in any other way, or in any other way appears to be of someone. And again, that changes the previous definition, which required to be a real image or a real film, in a way that, in theory, if you look at the design of the offence, it would apply to deepfake. So anyone that shares a photography of film, which could be a deepfake, which shows or appears to show another person in an intimate state, is committing a crime. And that is relevant in terms of the Online Safety Act, not only because the person who does it is subject to criminal prosecution, but also because the Online Safety Act imposes a series of duties on platforms, on search engines and user-to-user services, which include social media platforms, to put in place measures proportionate measures to tackle illegal content. So once the Act defines intimate deepfakes, or the act of sharing intimate deepfakes, as a criminal offense, as some form of illegal content, it also at the same time requires platforms to act and to put in place measures and processes and systems to deal with illegal content. And there are different ways the law tries to do that, and there's a little bit of a clunky language, and the technique that was employed by the legislator is such that a lot of the interpretation of the specific obligations require Ofcom, which is a regulator, to provide guidance and codes of practice. But the idea behind it is a platform should put in place measures to mitigate the risks of them being used to disseminate illegal content, and intimate deepfakes being one of them. But if you look at what Ofcom has currently put into the public domain, or put for consultation, the draft guidance on how platforms should interpret their duties of care, their duties to respond to illegal content, it's very much in the realm of taking down content if the platforms think there is reasonable belief that the person being portrayed did not consent to that content being created, which, when it comes about deepfakes, is very difficult to assess. It is very unlikely that non-consensual intimate content that is synthetic is going to show that the victim is under distress, or the victim did not consent to be portrayed, or there will be any kind of information, contextual information, that that image or that video is not consensual. And the other issue is that Ofcom also says, well, platforms, apart from signs of non-consent, platforms could also look for malicious intent or signs that the media has been leaked or hacked, which again is problematic if you think about non-synthetic content. But if you think about deepfakes, none of this is likely to be present. Other routes that platforms could, according to Ofcom's guidance, refer to is victims reporting that their content has been leaked. And again, if you think about the nature and how deepfakes are created and the source material, it's very likely that many victims will even know that they had been targeted. They're not necessarily going to know that their content is online to be able to report it. So one of the things that I find puzzling and kind of limits the effectiveness of the Online Safety Act is that even though the definition of harms and the offense, the sexual abuse, the sexual offense that the Online Safety Act introduces would, in theory, mean that non-consensual intimate deepfakes are a type of illegal content the platform should respond to. The way that Ofcom provides guidance to platforms on how to deal with that is very much limited and doesn't really apply to the context of how deepfakes are created and shared. And I would say that kind of the guidance is flawed in many ways, because even if you think about non-synthetic content, having the victim reporting every piece of content for that to take down to begin with is an issue. So I think a lot more could have been done from Ofcom's perspective to provide better guidance, more tailored to the nature of the harms to platforms to tackle the content. And then the final point that I want to mention in terms of the different bucket of issues that the Online Safety Act put in place are specific obligations to pornography providers or to adult content websites. And I think these are kind of two-pronged. One is a general obligation for any site that hosts adult content to prevent minors, people under 18, to accessing the website. So these are age gating obligations. And this is kind of very straightforward. If your website hosts any form of intimate content, you need to prevent people under 18 to access it. But another thing that the Online Safety Act is going to do is not enforced yet, but is coming soon, I would say. Depends a little bit on the Secretary of State to define the start date. Is that the Online Safety Act is going to become the main regulation for video sharing platforms. So any form of video sharing platforms, which is a kind of umbrella category under which a lot of pornography websites fall into, will be subject to the same kind of duties of care and safety duties that all platforms are currently subject to. So I did try to kind of explain this more for my own benefit, was the kind of this layered approach that many of the video sharing platforms are going to be subject after the video sharing regime comes into place. And the idea is that if they if video sharing platforms host kind of adult content or pornographic content, they would be subject to the age gating obligations, also to the video sharing obligations, and also to all the other kind of duties of care obligations of the Act. But this is something I'm still trying to get my head around, and there's not much clarity in terms of when the new kind of video sharing regime is going to come into place under the new Act. But given that the Online Safety Act requires so much of platforms, given that Ofcom is not very clear in terms of what platforms should put in place and how best they should provide safety procedures or safeguards in terms of non-consensual intimate deepfakes, one of the things that I've looked at as well is how good or how effective or how protective are current social media platforms systems of governance or systems of content moderation when it comes to this type of content. And I would say that many of them don't really make a distinction between the type of content being synthetic or not. And it's, as you would imagine, very difficult to kind of navigate whether or not the content would be fall under which of their kind of content policies for potential reporting and takedown. So if you're a victim, if you had your intimacy shared, if you are portrayed in a kind of non-consensual intimate deepfake, if you go to one of these platforms, what are the kind of policies that you could perhaps use to report the content? Most of platforms don't allow any form of nudity, but it's not clear all the time whether nudity is only real nudes or they also apply to synthetic nudes. And I would say that X is exception where it very clearly allows nudity, and X is, or formerly Twitter, was used to consume and to share added content for by many people, but it does have a clear rule that prevents non-consensual nudity on the platform. TikTok, on the other hand, doesn't allow nudity at all, has quite strict rules in terms of what parts of the body could be displayed, but it's very unclear from the rules whether that only applies to real images or also applies to synthetic content. And Meta's, and this is, I would say these are Meta's former policies. There is a new one that came into force last week before I had time to update the table. But Meta's former policy was very clear that it only applied to real nudes and not to synthetic nudes. So what I want to show with this kind of table is that really there's a patchwork of approaches on whether or not synthetic intimate content would fall or violate one of the policies of the kind of biggest social media companies. And that is kind of puzzling because for CSAM, which is child sexual abuse material, they all say CSAM is prohibited, be it real or synthetic. And I don't understand why that rule is so clear for CSAM. It's so clear that the policy protects the children, whether it is kind of synthetic or real content, but when you look at the other platforms' policy, like on bullying and harassment or nudity, it's not clear at all whether they also apply to deepfakes. So I think that a very kind of clear policy recommendation that comes from this study is for platforms to adopt consistent and symmetric policies across the entire suite of content policies so that they apply equally to synthetic and to real content. And this is actually something that Meta has done again last week. He adopted a new policy where it commits to remove content regardless of whether it has been created by AI or a person, if it violates any of the policies. Of course, there will be a difficult issue with enforcement, with actually being able to do that work that it commits to doing, but I think it's a really important first step. Also because it removes the requirement that people of content moderators, be it human content moderators or classifiers that most social media platforms use nowadays to moderate content, need to be trained to identify whether content is real or synthetic. Having that extra kind of hoop to jump in order to apply a policy sounds to me an unnecessary kind of challenge. So one of the recommendations that I make in my research is that platforms policies should be kind of agnostic in terms of the technology to create the media or whether it's synthetic or not when applying that content policies. And then finally, the kind of final step of the research is looking at AI regulation and looking at how AI regulation could help to fill some of the gaps that current platform regulation has. And I'm saying that because, as I mentioned, the Online Safety Act does bring positive innovations. It does make the prosecution of crimes potentially easier because of the wider definitions. It does place some duties on platforms, even though they are underspecified, and I would say Ofcom's guidance could be improved. But it also means that it leaves out of the hook important players in the ecosystems of creation and dissemination of deepfakes. And those, in my view, are the firms or the individuals or the people behind many of the AI tools that are used to create criminal content, which are the kind of violating non-consensual intimate deepfakes. So the argument that I'm advancing here is that this should be prohibited. The creation of non-consensual intimate content to begin with should not be allowed. And there are two sides to that argument. One is the criminalization, which is something that is currently on the table. There have been, like just last week, proposals by the government, and that follows proposals from Labour before, that seeks to amend the criminal justice bill to criminalize not only the sharing, which is in the Online Safety Act, but yes, please. That's okay. So there has been amendments to the criminal justice bill to criminalize not only the sharing of content, which is under the Sexual Offences Act, thanks to the Online Safety Act, but also to criminalize the creation of non-intimate content, synthetic content as well. And this is kind of the government committing to tackling the issue of deepfakes, making it illegal or criminalizing the creation as well. But my argument here is that this is great, also because online AI tools don't fall within the Online Safety Act definitions of platforms. They are not user-to-user platforms, and they're not search engines per se. So the Online Safety Act does not apply to, if you think about ChatGPT, Gemini, or Llama, none of them, and the kind of sister brother platform tools for creating images and videos. So like Deep Journey, none of them are within strictly the remit or the umbrella, the scope of the Online Safety Act. So they're in theory off the hook. And then the government proposals, by criminalizing the creation, places the responsibility on the individual behind the technology, typing the prompt and pressing enter and creating the kind of violating content. But it does not place any form of obligations on the companies, on the services, on technologies that are used to create the content to begin with. So what I would say is that there is a kind of a loophole still in terms of the regulatory, the law, the legal response to the issue, whereby, again, we are putting a lot of responsibilities on the individuals through criminal law. And one could question how effective criminal law is in being a deterrent to this type of harm to begin with. And again, some of you in the room are probably best placed to answer that question than I am. But my argument here is that it is insufficient. It does not, we need to require the companies putting those tools out there to do something or to have safeguards in place to prevent the creation to begin with. And if you look at the kind of usage terms of some of the most used kind of platforms out there, and that's ChatGPT's policy, which also applies to DALL-E in terms of what can you and cannot do, is very thin and is very broad. And if you compare that with the content policies of any social media platform, I would say that it's probably like a tenth of what any social media platform would have in terms of usage policies. So you have to comply with applicable laws, which is great. And it's kind of obvious. We all should comply with the law all the time. Don't compromise the privacy of others, engage in regulated activities. Don't use the service to harm others, and respect the safeguards. It's not very clear what type of content can and cannot be created, and what will happen if you create things that are not allowed. There's no kind of suspension remedy or no form of penalty that a user could be subject to if they were in breach of these rules. And this is Google's rules on generative AI as well, which applies to Gemini. And if you look at the bullet point number 3, which is the last one, there are 3 bullet points. The number 3 does say that generating sexually explicit content, including content for the purpose of pornography sexual gratification, is not allowed. But again, it is not clear how this rule is enforced, what the penalties would be, and what Google is actually doing to prevent its tools from being used for that. And I would say that one of the big challenges that I've been reading about, but again, I'll welcome your thoughts and comments in this space, is that whilst it might be easier to place responsibilities and obligations on companies like OpenAI and Google, if you think about open source models that has been made available in repositories such as GitHub, and I think Llama is open source, people could tweak the code, and then there wouldn't be kind of a chain of responsibility that would make it possible to place obligations on the corporations or the individuals behind the models to make them put in place the safeguards. So I think that is a challenge here, to which I don't really know the answer. But I think if we start with the big companies, the ones that we know, and the ones that are widely used, to make sure that their tools are safe from that perspective as well, I think that could be a good starting point. But looking at the government's current proposal in terms of AI regulation, I wouldn't hold my breath, because the UK AI white paper, which is currently kind of the current thinking of the government in terms of AI safety and how to regulate AI, does not mention the use of or the creation and dissemination of non-consensual intimate deepfakes as being an issue or being a risk at all. It does mention the use of AI the risk that AI poses to information, trust information, and how deepfakes could be a risk from that perspective. As I said, a lot of the debate has been skewed towards misinformation and deepfakes used for that. But the AI white paper makes it clear that any form of intimate image abuse using deepfakes would fall within the remit of the Online Safety Act, which one, as I argued, is not adequately framed for the issues of deepfakes. And 2, none of the companies that are putting forward products, AI products, in terms of OpenAI, and any of the AI companies would fall within the remit of the Online Safety Act to begin with. So Google could be within the remit because of YouTube as a platform, but Gemini would not fall within the scope of the Online Safety Act. So the government's proposal doesn't really acknowledge the gap in terms of how to regulate safety and the creation of harmful content, considering that they don't fall within the Online Safety Act kind of scope. So that is kind of, in sum, what the kind of path that I navigated through in my research. I first tried to kind of pin down a concept or a definition of non-consensual intimate deepfakes as a form of image-based abuse, sexual abuse that presents unique challenges, and how recognizing the issue as a form of image-based abuse helps to shape better legal and policy responses in terms of identifying the dimension of the problem, but also not using kind of terms such as deepfake pornography. Then I looked at the UK Online Safety Act and how it has introduced new criminal offences that could apply to this form of syntactic content, but the limitations that the current guidance provided by Ofcom presents. Then looking at social media policies, the fact of the lack of symmetry in how the rules apply to content in terms of being syntactic or non-syntactic made them really limited, and also the more kind of responsive, reactive approach that they adopt in terms of requiring users to report violating content so it can be taken down. There's little in terms of protecting the victims to begin with. And then I argue that AI regulation can help to kind of close that gap by requiring the tools and the companies behind the tools to put in place safeguards that are very minimal, I would say, would mirror the content policies that social media platforms have developed and enforced over time to prevent the creation of the harmful material to begin with. So I think there are responsibilities and kind of legal measures that could be distributed across the deepfake kind of environment, across actors. So not placing responsibilities on individuals, of course, the people who create and share it, but also in the kind of wider ecosystems of actors, including corporate actors who have responsibilities to share in that regard. So this is kind of the sum of the arguments in my paper. I'll be very interested in hearing your thoughts, any comments, any suggestions, and test some of the arguments that I put forward, both in terms of the technical aspects, but also like the criminal elements, which are the ones that I'm less familiar with. And I think we have a lot of expertise in the room for that. Thank you very much.
Yeah, with plenty of time for questions, and I actually had one, so I start us off.
Yeah.
I wasn't clear what you wanted from the AI regulation.
Mm-hmm.
Let's assume for a moment that there was some sort of scenario where making a consensual deepfake of intimate image or video was useful, right? That wouldn't be illegal, obviously, right? If it was consensual or the person doing it themselves or whatever they wanted to do. Then what's the obligation on the technology creators? I mean, so you can't just outrule the technology outright, because it's not as if the technology was illegal. In that case, it wouldn't be.
Yeah, no.
Yeah, and so what do you want to regulate?
I think my proposal is a bit more radical. Yeah, I think my proposal is a bit more radical, and I do recognize that not all forms of intimate deepfakes are harmful, and that's something that I do try to kind of explain in more detail in the paper I did enjoy this presentation. So thank you for the question. I agree with you that not all forms of intimate deepfakes are harmful, and there is a universe of syntactic intimate content that could be created with the consent of involved parties. But given the difficulty in identifying consent and the fact that the technology is not at a point where you can easily identify and put in place the safeguards that would check consent beforehand, my proposal is to ban all forms of intimate deepfakes from being created. And I do recognize that there will be some kind of chilling effect in kind of legitimate content that would not be outright illegal, that could be kind of affected by that. But I see that as kind of a cost that society-wide would be reasonable to bear because of the benefits of regulation and legislation. I would say that, again, it's really difficult from a policy and regulatory perspective to distinguish or to make the cut of where we draw the line. And I would say that in that sense, because of the, and I think that's also the proposal that the government is putting forward of the criminalization of creation of all forms of intimate deepfakes, is that it's too hard to, at this moment, in terms of our technological development and the enforcement tools that we have at our disposal, to make the distinction between consensual and non-consensual intimate deepfakes. So all forms of synthetic intimate content should be banned.
Yeah, it's quite radical. I mean, maybe for this type of content in an area, that could be acceptable if you start weighing up harm versus benefits, because I'm coming right on the, what are the benefits? Maybe you could argue for some sort of film industry or something, there might be some sort of benefits. But otherwise, I'm coming up, very light on the side of benefits. So
Yeah.
Is that the argument, though?
That is the argument. That's the argument.
Just the balance is so
The
much.
balance of harms would say that, I think on balance, given the benefits and the potential for harm that exists by not putting in place in the ban, the kind of limits that we impose in creative industry or some kind of like, adult performance that would use the technology, would the harm they will suffer from the ban would be, compensated by the good that the law or the prohibition would bring to all other parties that could be potentially benefiting from it. I know it's hard, radical, and I do kind of spend some time making kind of detailing that aspect in the paper. And it is not, again, it's not from a moral harm perspective, because I fully agree with you. There is no a priori prima facie harm in someone creating a synthetic intimate content consensually. That I wouldn't say there's a harm in that, but because of the difficulties in distinguishing between and the kind of the balance of harms, the proposal is to ban all forms of intimate deepfakes.
I don't want to monopolize the discussion, but yeah, okay, no one else is trying it out. So the difficulty, of course, is that yes, you could ban all the things where it's very easy and kind of pre-made for the purpose of nudifying images and so on. But the technology there isn't kind of a step change between other forms of manipulation and the nudifying. Right? There's this gradation of steps. At what point does it become illegal? Right? And there's some things you could, I think, fairly easily define, where it's just about a prompt and then you get it.
Yeah.
But there are technologies up front from there where you would need to do a bit more work and you could still make it work, right? So where you see one problem, right?
I do.
Draw the line and say, oh, this is still okay because it's just changing the color of clothes. But this one isn't okay because now it's nude, right? But there isn't a clear line between the two, I believe. Yeah? So technically speaking, you could offer a service that's very close but not quite, or a bit further away. So where do you make it illegal? You can't make all image manipulation illegal. I mean, that would be maybe somewhat too harmful. Yeah,
no, I totally agree. And again, that is not a proposal. And I think where to draw the line is something that from a legal perspective it's not even that easy for me to say, like, what is intimate content, because there is even a debate in the literature in terms of what constitutes intimate content. Is it only when it shows parts of the body that are like uncovered parts of the body? Is that intimate? If you think, and one of the debates that has been going on, for example, if there is an aspect of someone's life they would prefer not to be exposed. So if you think about, for example, a Muslim woman that is portrayed not wearing a veil and the family doesn't know that she doesn't wear a veil, would that be an intimate image that could be used to her harm, even though it's not necessarily would fall into all forms, all conceptions or all concepts of intimate? Is that a form of abuse as well? And the line, even in legal terms, is not that clearly defined. But I think that is a challenge that the legal community and the technical community might need to address together. So perhaps in the context of the AI regulation debate, this is something that we could start to think about. And it comes with social media. Social media is not easy as well, right? Many social media platforms have content policies on nudity, and they define nudity in many different ways. What is legal and what is not legal, what's allowed and what is not allowed? Why does Instagram ban female nipples but allows male nipples? And when you're breastfeeding, it's okay, but and it is part of a breast cancer campaign is also okay, but in any other scenario is not okay. And these arbitrary lines that the social media companies have developed over lines and tested, and even nowadays the enforcement is imperfect, but that is an effort being made. And I think some form of middle ground, or like a gray area, where we could try to develop a policy that would be probably not perfect to begin with in terms of what is and what is not legal content for these tools to create. But I think that an attempt to draw the line would be beneficial, because at the moment there is no line at all.
Sarah has a question, I think.
Yeah, so just to add to that debate about how we criminalize or legalize certain acts, you know, I'm a civil lawyer, but have done criminal law, you know, years ago, and these are debates that happen, you know, particularly under Sexual Offences Act. What, you know, where are the boundaries, and where do we move from what is lawful and what isn't? So this is sort of an ongoing debate offline as well as in the online space. So I think I agree with B on this kind of spectrum of this approach of reducing, you know, where's the greatest harm, starting with that and then working back from that. Whereas the situation we often find ourselves in law is, you know, people at the most vulnerable are at most risk, and it's often women. So I think the starting point really has to be the protection of women and children, I'd say, and then reining back from there. And those sort of grey areas with criminal law are still, there are still so many grey areas, and they're sort of theoretical and culturally defined. But yeah, I think it's really a debate that needs to be out there, really. So yeah, thank you, B, for putting it on the agenda, and yeah, looking forward to hearing more. So thank you.
Thank you, Sarah. And if I could just kind of add something to that, and is that I am personally skeptical of criminal law as a tool targeting individuals and prosecuting individuals that have been using technology to begin with, because I think the technology should not be in the hands of the individuals. So if you prevent that, the kind of close off app, which is very popular in its own kind of Apple Store and Google Play, you can download an app called Clothes Off, put someone's photo there and unclothe the person, and that's okay. But then if a 13-year-old teenager downloads the app and does that to the person sitting next to him in the classroom, that is a crime, and that person can be prosecuted. The child can be prosecuted for that, but the people behind the technology that enable it to begin with is not going to be responsible. I think the problem is in kind of the incentives there, right? And because I'm not an expert in criminal law, this is a difficult place to be talking from, but I do think that in terms of the individual deterrence of criminal law, I'm skeptical of how helpful putting children in jail for that type of behavior is actually going to be. But on the other hand, by making things illegal, then you allow a lot of other kind of levers and pillars that we have in place to kick in. So, for example, the safety duties of the Online Safety Act can only be kind of put in place once something is illegal content, and to be illegal content has to be an offense. So to begin with, I'm critical of the Online Safety Act approach to focus only on illegal content. If we had in place a version of the Online Safety Act that we had before, where platforms had duties and had obligations also in terms of harmful content that wouldn't necessarily have to cross the threshold of illegality, we have a suite of tools available that wouldn't necessarily require criminalizing every piece of content or every new technology to make platforms accountable for them. But we don't have that anymore. The current version, the approved version of the Act, focuses in terms of adult content is strictly on illegal content. And that makes it required to criminalize things so we can actually put big platforms do something about the content. So that's kind of a flaw, I would say, of the Online Safety Act. And I think that there was another point, but now I forgot, and I'll come back to that at a different point.
Okay. I think David is waving at me. David, you want to say something?
Yeah, thanks. I have a couple of things to bring up. One is, I'd be interested in the distinctions between the Online Safety Act and the EU's Digital Safety Act with respect to the things you've been discussing. And the other thing that I'm not clear on is what the expectations are of the large platforms. Are they intended to try to detect the illegal content before it's posted or immediately after it's posted without expecting anyone else to alert them to it, which is nigh on impossible, since I don't think AI tools can determine accurately whether things are AI generated or not? Or is it about responding to requests to take material down within a certain length of time, or what is it? What is the expectations of the platforms?
Thank you, David. I think they're good questions. And I think that for the second question, they're like, what's the expectations as it is with the Online Safety Act, and what should be the expectations kind of like a normative act level, like what I would imagine they would be. But I'll come back to that point. In terms of the difference between the Online Safety Act and the EU Digital Services Act and how different they apply, I think the crucial distinction is regarding the point I was just making in terms of the Online Safety Act requiring content to be illegal so that platforms have any duties regarding it. The Online Safety Act, safety duties and risk assessment duties only apply to illegal content. So they require some form of illegality, definition of illegality to apply. That's not the case with the Digital Services Act, where the obligations that bind platforms require platforms to assess systemic risks, broadly conceived. This includes risks of the systems and the process of the platforms being used for illegal content disseminate and produce illegal content, but also includes a bunch of other risks, for example, risks to democracy, risks to the health and safety of people, risks to minorities, risks to human rights. So there's a bulk of different types of risks that could be within the platforms would require to identify and address under the Digital Services Act, the EU law, that under the Online Safety Act are not strictly within scope, because platforms would only have duties towards something that is considered illegal. In the EU Digital Services Act, because the EU is kind of delegates to the member states the definition of legal and illegal, it depends a little bit in which country this form of abusive content is illegal to decide on whether or not that would be considered criminal content. But even though syntactic intimate sexual abuse would not necessarily be illegal in all EU nations or be in criminal codes across all the EU nations, that wouldn't necessarily be a problem, because platforms would be required to assess risks of harm more broadly, even if the content is not illegal. I'm not sure if I'm clear on that point, but the difference is that EU DSA, the legal-illegal kind of distinction depends on member states' individual laws, but that doesn't matter in terms of whether or not platforms should do something about syntactic intimate content, because the Digital Services Act applies to a wider set of risks and not only illegal content. In that contrast with the Online Safety Act, where platforms are only required to assess and mitigate risk regarding illegal content. But I don't have data yet in terms of how well the Digital Services Act has been forced to deal with this type of harmful content. And that'll be something that will be good to look at. Would platforms that are regulated by the GSA as being very large online platforms doing better at taking care of this type of content than other platforms? I don't know, but that would be something like an empirical question that will be interesting to look at. And the EU, just to add, has an upcoming regulation, which is the EU Directive on Protecting Women Against Violence, that also proposes the criminalization of this form of image-based abuse across the EU level. So if that happens, then there will be a kind of a union-wide legislation prohibiting image-based sexual abuse, including deepfakes. So that's a long answer to the first question, which is that there are differences, but I'm not sure yet in terms of the practicality, the empirical evidence of how different the scope of the laws have translated into different applications by the platforms. And then the second question that you asked, what is it again? I forgot.
It's to do with what's expected of the platforms.
Oh, yes.
They have to mark something as simply synthetically generated, take it down only when someone tells them to take it down.
So that's a great question, because the Online Safety Act says nothing about it. The Online Safety Act does not clarify any of the details of what the expectations are for platforms. The Online Safety Act has kind of two types of obligations when it comes to platforms. One is to identify, so risk assessment duties, identify the risks of their platforms being used to disseminate or to cause to amplify any form of illegal content. And the second is a safety duty, which is to put in place systems and processes that would minimize the risk of users encountering illegal content or prior to illegal content, and respond to when some form of illegal content is reported. So it's not that, and again, the kind of roundabout way the legal obligation is defined is not the platforms have the duty to take down content. They have the duty to put in place systems and processes that would enable a user to report content and they take it down. So it's a procedural obligation. So the Online Safety Act is not saying platforms need to take down every piece of content. So the measure of success for a platform to be compliant with the law is not the percentage of illegal content removed or took down. The measure of success is not set in the law at all and not set in the guidance at all, which is how well they put in place systems and processes that would mitigate the chance of users encountering prior to illegal content, or that would enable users to report and take down illegal content. So that's kind of a difficulty in terms of what should platforms be doing, because the law doesn't really say. And then Ofcom is trying, and I would say they're trying their best with what they have to interpret the law as it has been passed by Parliament and to provide more guidance. But I also think that the approach in terms of requiring the platforms to identify what is illegal and what is illegal content, because the treatment the platforms should give to content heavily depends on the nature of the content, whether content is legal or illegal. So platforms have to identify the legality to begin with, and they're not well placed to do that, as David mentioned. I mean, it would be really hard for platforms to put any sort of mechanism in place beforehand, like an automated content moderation, to identify the nuances of what the content requires. So yeah, there is no specific requirement of platforms should do, apart from putting in place systems and processes to prevent users from encountering this type of content, and then put in place systems and processes that would allow users to report and then take down content once reported.
Okay, okay, one more. You're running quite late, but a quick one, yeah?
It's okay, I can take it bilaterally.
No. Just
No, I'm doing my dissertation on similar topics, so I'm just roughly brainstorming. So do you also think, apart from policies, the platform should also focus on developing technologies that can detect such things faster? Has there been any discussion or research on that where the platforms are owning up to coming up with more innovative technologies?
I mean,
not let it happen in the first place. The policies are there, of course, they'll be there.
I think there's been discussions of platforms using technologies for content moderation in general, beyond that form of harmful content, with different levels of success. And again, it's really hard, and I would welcome comments from others that are more kind of experienced in terms of why is it so hard, but it is really hard for platforms to kind of enforce content policies accurately. But we have seen it's a trend that increasingly more content moderation is done using classifiers and kind of automated content moderation, and not like a human being behind it saying this is legal and this is illegal. So I would say that with the type of content that we are talking about, the non-consensual intimate content, it might be hard for this kind of classifiers or automated content moderation to identify whether it is consensual or not, whether it's synthetic or not. So that puts the kind of current tools into challenge. You might need new tools or better tools to do that. I would say platforms would be encouraged to do so and to invest in the form of technology. But I would say there's also the risk that a lot of legitimate content will be taken down as a form of kind of side effect.
Such a nuanced sector.
It is. And I mean, in the paper, when I have a bit more time and space, I do discuss a little bit of the kind of chilling effects that wide nudity policies could have on some forms of vulnerable groups. For example, LGBTQA+ users who don't really conform with all the kind of stereotypes, norms in terms of nudity that platforms have in place. Or there is also a really good paper that I would recommend you in terms of content creators, other content creators that are disabled and their bodies that don't conform with all the definitions in terms of nudity as well. So the non-conforming bodies could be an issue in terms of how kind of stereotypical gender kind of norms are designed and enforced. And unfortunately, we know that the way that many of the classifiers work is based on this kind of more kind of heteronormative forms of bodies and rules. So it is a challenge. It's not an easy one, and I think it's good because that keeps us employed in a way.
Well, I think on that note, you're running quite late, so thank you very much, Beatriz. And that's us sorted for today, and then we have the next seminar about next week, I think.
Thank you so much. Thank you for the opportunity for the invitation. It was a pleasure.